Friday night, a judge approved the House versus NCAA antitrust settlement. Those 76 pages are poised to rewrite college athletics as we know it and how student athletes will be compensated. KBTX senior Texas A&M sports writer Travis Brown has been tracking this case for years now, and he joins us now to help us make sense of where we are now that a settlement has been reached. Travis, thank you so much for being here.
Always glad to be here.
All right, let's start with some background about this case. It's been going on, as we said, for years now. So how did we get here?
Yeah, so the first iteration of this was filed in 2020 by Grant House and Sedona Prince. Grant House, Arizona State swimmer, Sedona Prince, Oregon TCU women's basketball player. At the time, they wanted just to be able to earn money for their name, image, and likeness. And as those laws kind of came into place and rules in 2021, it pivoted and shifted a little bit so that it was just that they wanted to be able to revenue share with the athletic departments for the use of their name, image, and likeness, and for them and future athletes, and wanted back pay for the name, image, and likeness money that they didn't get. That's what ultimately was settled between the two parts. It was an antitrust case under the Sherman Act, and the reason it needed to get settled is because if the NCAA would have gone to trial and lost, it would have been triple that number with treble damages going to antitrust cases. So settling was the better of two evils, I guess, for the NCAA.
All right, so how will college athletics change now because of this settlement?
I think the biggest bullet point in all of this is revenue sharing. College athletes appear on broadcasts of games, and there is money made off of concessions, ticket sales to go see these athletes. So the athletic departments will get to share, if they opt in, will be able to share some of that revenue with the athletes. That's 22% of a general typical athletic department's budget, which in the first year will be about $20.5 million. Also, there'll be the limits on scholarships were taken away. For A&M, that looks like a difference in 155 new scholarships will be added in for athletes, but there is going to be roster limits put in instead of scholarship limits like there used to be. So teams will be capped at a certain roster limit. There also is the development of this College Sports Commission, which is a third-party entity that will govern the NIL deals, the revenue sharing cap, and can also issue penalties, punishments to schools if they violate those things.
And as I understand, that's still kind of being developed right now. So we're still kind of in this wild, wild west. So does this House settlement kind of solve all of the problems that college athletics face?
No, we're still. I've been at this since 2020. We have been. It's still going to continue with other litigations about different parts of the settlement and revenue cap enforcement. This new entity, all that will be under scrutiny. And I talked to Sam Ehrlich, who's a professor over at Boise State, and this was kind of his take on where this goes in the future.
We're going to be talking about antitrust law more and more, and that's all a balancing test. That's all. Do the anti-competitive restrictions overwhelm the pro-competitive benefits? And I can certainly imagine a court saying no, that they don't, that the pro-competitive benefits of having competitive, more competitive balance, more kind of stability in college sports outweigh these individual boosters and individual collectives' concerns.
So basically what he's saying there is that we're done, but we're nowhere near the finish.
Correct, and that the way that NIL is distributed moving forward is going to be under scrutiny. We're going to have to kind of tweak that now that we have revenue sharing in place.
All right, Travis, thank you so much for tracking this, and you can find all of Travis's work up on KBTX.com. Thank you so much.